Assalamualaikum and hi. Thank you for being here today. I'm Azmina Amni Azmi from Group 3. I'm here today to talk about case scenario 3 based on an actual court case of Spencer vs. Halim 1870. In this short presentation, we will cover on the summary of the law case parties involved in this case, the right and duty of related parties, the issues and problem that has been raised, the element of a contract that involved, the case verdict, and lastly, the conclusion of the case. So that's it in the introduction of our presentation. Here now is my team member, Muhammad Haiqal bin Muhammad Halim. He will talk about the first key point, which is summary of the law case. So let's get started.
Mr. Azim saw the advertise open a bid by JKR for the road repair in daerah Kuala Selangor. As director of Bina Semangat Construction Senjalan Berhad and his team thereafter to decide to submit a bid for it with the best of his knowledge, the most competitive bid in order to improve the likelihood that the company would be awarded the contract. But unfortunately, JKR decided to choose another party Senjalan Berhad to be awarded the tender, even though that company bid higher than Mr. Azim's company did. When he saw the outcome of the tender, it was then that he made the decision to take the case to the court. Was a request for bids capable of functioning as a contractual offer to sell to the person who submit the highest price. Mr. Azim may not be able to win this case. This is due to the fact that the online advertisement is only an invitation to trade and not an offer to create an agreement between the parties. Moreover, Bina Semangat Construction Senjalan Berhad is categorized as one of the companies known as non-compliant.
Hi, Assalamualaikum. My name is Sufi Aiman and I will continue with parties involved in this case. Okay. In this case, we have defendants and plaintiff. Okay, the third party refers to the individual or organisation who are directly involved in the lawsuit. Okay, for defendant are those who bringing a civil lawsuit, and the plaintiff are those who are being sued in a civil case or accused in criminal cases. During the trial, the parties may be represent the counsel tables with their attorneys. Okay. In scenario 3, the defendants, the person who being sued and accused of committing misconception and make mistake in advertising and make decision that resulting the final acceptance of offered tender is Jabatan Kerja Raya or JKR. While according to the court case of Spencer v. Harding 1870, the defendant of the case is Harding. Next, for the plaintiff, in scenario 3, the person who claimed and brought the claim to court, which is to sue the defendant for the disappointment damage, is Mr. Azim, who present himself as on behalf of his team and company of Bina Semangat Construction Senjalan Berhad. Thus, the claimants or plaintiff is an individual who charged legal action against the defendant is to recover from their losses caused when working for the defendant, while according to the court case of Spencer v. Harding 1870, the claimant of the case is Spencer.
Assalamualaikum. My name is Rasyidah Wani Binti Muhammad. For the right and duty of related parties to make decision on item relevant to pre-qualification of tender, and to approve a list of participating tenders, to establish an expert tendering group, to select a consultancy organisation or a professional tendering organisation pursuant to this law, to represent the investor in action as the party calling for tender, to approve the list of tender who has certified the technical requirement and the list ranking the tender, to approve the result of direct appointment of contractor in the case stipulated in sub-clauses and of Clause 1 of Article 20 of this law to be responsible to formulate the requirement applicable to a direct appointment tender package to be able for the content of contract for signing a contract with the selected contractor and for fulfilling undertaking set out in the contract signed with the contractor to be legally liable for the process of selection of contractor pursuant of this law, to pay compensation for loss and damage to related parties pursuant to this law if such loss and damage was caused by the investor fault. To provide information to be tendering newsletter and to the tendering website, to resolve a protest regarding tendering, and last, to maintain confidentiality of document or tendering pursuant to the provision of this law.
Hi, my name is Baiti, and I will discuss about the issues or problems that has been raised from the case. First, whether the tender opened by Jabatan Kerja Raya JKR is only invitation to trade. Next, whether Mr. Azim has the right to win the case. Third, whether JKR is bound to accept the tender from Mr. Azim. And the last one is whether there is a binding contract between JKR and Bina Semangat Construction Sendirian Berhad.
The element in this case is invitation to trade. It implies to invite others to make a contract offer. It means a party that makes a contractual offer is indicating that they are willing to be legally bound by terms of the contract. This shows a desire to negotiate but not to be legally obligated. An invitation to trade encourages the other person to make a proposal. Not usually the top or lowest bidder wins auctions. The bid is more of an offer to buy than an invitation. Advertisement can sometimes be considered offer.
Based from the issues raised, we conclude the court's decision where the court held that the tender made by JKR is an invitation to trade, not an offer. Mr. Azim does not have the right to complain as JKR is not at fault for rejecting his offer. The tender opened by JKR is aimed for any construction company and the one who will accept an offer. As the table results shown, Bina Semangat Construction Sendirian Berhad is non-comply, which means Mr. Azim did not meet the requirements of JKR for the road maintenance. Moreover, it is not stated that the price of the bid should be lower for JKR to accept their offer. So, JKR is not bound to accept the tender from Mr. Azim. This case is similar to Spencer vs. Harding 1870, where the defendant did not accept plaintiff tenders which complied all the requirements and offered the highest bid. The court held that it was an invitation to trade, not an offer, and it is not stated that the defendant undertakes to accept the highest tender. Furthermore, there is also no binding contract between JKR and Bina Semangat Construction Sendirian Berhad, as there is no offer and acceptance happen between both companies. Therefore, the court held that JKR opened the tender as invitation to trade, not as an offer. Mr. Azim has no right to take legal actions against JKR because there is no agreement existed and no acceptance towards the offer. Hence, JKR will win this case.
In conclusion, based on an actual court case on Spencer vs. Harding 1870, the scenario case of local authorities Jabatan Kerja Raya, JKR and Mr. Azim is not an offer but simply an invitation to trade. Jabatan Kerja Raya JKR will have win the case because there are no requirements stated on accepting the lowest bidder. Mr. Azim have been mistakenly take a call for tenders which is invitation to trade as a contractual offer if he bid for the lowest. Thank you for listening. You are a therapy audience.